I will now call the case of ASV versus Vineyard Church of Overland Park, Vineyard, USA, Mark Warner and Robert Bloom, case number 127118. Counsel, you may approach.
May it please the court, again, Joel Riggs appears on behalf of the appellee and petitioner, Robert Bloom. Thank you for taking this appeal and this petition up, and being present and ready to deal with this important argument on this important case.
Mr. Riggs, let me just clarify, you did reserve 3 minutes for rebuttal.
I did.
Okay, thank you.
Thank you,
You may
Judge.
proceed.
Thank you, Judge.
Sorry to interrupt.
Yeah. First thing I'd like to address is we had a email order from Justice Rosen wanting to make sure that we could address a certain jurisdictional issue that I believe the way I read it was related to with respect to my client. I had a cross appeal with respect to the portion of the summary judgment order that said, well, even under the old statute of limitations, we think summary judgment should have been granted. And there was an issue. It's like, well, if there's a denial of a motion for summary judgment, then that's really not a final order. So would you have jurisdiction? And my response to that is, under these circumstances, yes, you do. There was one summary judgment argument. There were supplemental pleadings based upon the amendment of the statute, but there was one order that was issued by the district court that dismissed any and all claims against all defendants, thus terminating the entirety of the litigation. Therefore, it would be a final order. I would also point out that this is a summary judgment situation where any appellate court has de novo review of any legal issues based upon the uncontroverted factual issues that it can consider at any time. And then we, of course, have the doctrine of being right for the wrong reason. So the court can take it, it can determine, well, if the Court of Appeals or even the trial court got it wrong with respect to the law, any appellate court, being the Court of Appeals or the Supreme Court, can consider any legal arguments appropriately, enter the final order, and therefore we do have a final order. I don't think there's any jurisdictional issue. And plus that issue on the cross appeal, I doubt that's why the court granted the petition for review. So I'm not going to argue those facts and that law because we're here on the fact that the trial court granted summary judgment based upon basically a bright line drop dead date with respect to filing claims.
Mr. Riggs, before you move over to that, what's your legal authority for jurisdiction? I realize that's the outcome you want. I'm trying to figure out what the authority is for it.
For the cross appeal?
Having jurisdiction over the cross appeal.
We have.
You would agree it's not a final, it would not be a final order. And we've never taken a summary judgment motion in that posture where there's a denial of summary judgment.
Yes.
So again, what's the legal authority for us having the ability to hear that issue?
Well, because there was a final order, because when Judge Vano got done issuing his summary judgment opinion, the case was completely terminated. And so, and part of that order, the memorandum.
It was completely terminated once Judge Vano decided the case the way he did.
Yes, and that was the final order that is subject to the appellate court's jurisdiction. And that part of that ruling included his, what I would assert is arguably dicta with respect to, even if the old statute applied, there'd be fact questions.
So any statute or case law that matches these facts that you can point us to that says
I couldn't find one that exactly matches these facts, but I can refer you to the case that the that Justice Rosen's cited in his in the order that we sent with respect to what constitutes a final order. I believe that was in the posture of an order on arbitration, and because it determined that the case was going to be continued to be litigated, whether or not in the court or in arbitration, the matter had not been finally concluded. And in this case, it had been finally concluded. And then we have the right for the wrong reasons, Judge, that the legal analysis that the district court considered can be considered by any appellate court because of the summary judgment standard. So there wasn't any case ongoing after the district court made its decision, and there was a final decision and no further litigation was pending, unlike a situation where you just deny a motion for summary judgment and the parties roll on down the road towards trial. There was no rolling on down the road towards trial in this case. And the reason, I'm sorry.
No, go ahead.
Okay, thank you.
No, you're fine. Just to let you know, we'll grant you a little more time to argue while you're here.
That's fine. In fact, I was going to say, Justice Rosen, that I really don't have much to say with respect to why we're here before the court. It's, I believe, to be a very simple issue. The district court made a determination and read the statute at issue and said, well, we have a new statute of limitations. The legislature indicated that it wanted it to apply retroactively to any and all claims. And I am therefore following the legislature's law that it passed and am granting a summary judgment based upon the fact that the statute of limitations that was passed in 2023 indicated that there was no more discovery rule, and the legislature made a policy decision with respect to that issue, but it also made a policy decision with respect to actually extending what we'd call, I think, the age limit with respect to filing a claim of this type, and it extended it from basically 21 years old to 31 years old.
Okay, so let's say that we're convinced by what you say and that the text clearly shows legislative intent for retroactive operations. But regardless, don't constitutional, and this is what the Court of Appeals found, limits, constitutional limits prevent applying the amendment to the plaintiff's case in this case, because doing so would violate a vested right in her already filed claim under the three-factor test?
No, and that's what the district court judge made that determination, considered those issues, and made a determination that vested rights were not in play. And I believe that any sort of analysis of this court's prior rulings with respect to whether somebody's interest in a statute of limitations, whether you're a plaintiff or a defendant, is a vested right. And I believe this court has previously stated that it is not. And
It is stated what? I'm sorry.
that it is not.
That what is not?
That you don't have a vested right in the present statute of limitations when the legislature takes it under its prerogative to state that we are going to pass a statute of limitations, and if we decide to make it retroactive, we can do that, and it is only procedural, and then this courts have determined it is only procedural in nature and doesn't involve substantive rights and doesn't involve the application of...
Expand on that a little bit. Why is this solely procedural? Isn't there aspects that's substantive? The claim has been filed. It's proceeding in court, and suddenly there's a change in the statute of limitations. Yes, that's a procedural aspect, but there's a substantive vested right too, isn't there? Hasn't that attached in this in this, under the facts of this case?
I don't think that when the legislature takes it upon itself to pass the law and make it retroactive, I think that all parties, whether you're on the plaintiff side or the defendant side, are going to be bound by that change in the statute. As this court has previously said, the Supreme Court has held that a party has no vested right in a particular statute of limitations, and that retroactive amendment to a statute extinguishing a right to prosecute an accrued cause of action does not implicate due process.
Right, but what case are you relying on for that?
That is In re Hunt. That was the Court of Appeals opinion, and they were citing the Harding case, the Harding versus Casey Walls, which was I believe that was a product liability case that determined that the defendant did not have a vested right in the expiration of the statute of limitations, and the legislature could amend the statute of limitations, make it retroactive, and there was no vested right or due process considerations involved in that sort of situation.
In that situation, was the claim already filed? Was the lawsuit pending?
Justice, I can't speak to whether the lawsuit is pending, or not. I can't recall the specific
But
fact.
doesn't that make a difference?
I do not think it makes a difference, because the legislature is announcing a law, and just like if we're going to trial in some matter and there's the decision by this court on some certain issue, and we proceed to trial on that, we're going to be trying it on the law of the case as it stands as we're progressing through. And when the legislature specifically states it wants to not only, in this case, expand and extend the statute of limitations and revive claims against defendants, that you would have to say if that you would that they had an interest that is not invoked, that there is no reason why, just because the lawsuit has been filed, that grants more rights than if a lawsuit has not been filed. I don't think that's a material distinction. I don't think it's one that is specifically addressed in prior opinions of this court or other courts that have addressed the issue.
How does the Harding case help you? That was about reviving a dead claim. And plaintiff had a claim at the time the statute of limitations was done. So I'm not sure why I would hold Harding too close to my heart if I were in your position.
Well, and that's what kind of what I was been thinking about, Judge, is that is a determination where a court has said you have no vested right in the expiration of
It's a dead claim, but she had a viable claim. I recognize you had issues over the discovery, but it's still a viable claim pending resolution of that discovery question. Harding doesn't have that.
Harding doesn't have that, but are we going to treat the parties differently? It's the same. It's in that case, the defendant did not that. If taking your argument, then the defendant had a vested right in the expiration of that statute of limitations.
I'm understanding your argument. Sorry for interrupting, but I'm understanding your argument to be once the legislature decides this, it's done. And all of our case law goes to another step. And that step is to apply a 3-factor balancing test. So it's not done. We've got to apply that 3-factor test. So, that means we've still got more to analyze. So it's not just a done deal. Let me move you to Judge Vano's an analysis of the second factor, which was how plaintiff's case was impacted by the change in the statute. And Judge Vano, as I read the decision, said on that second factor that her opinion, her impact is really not that great, because he could still be convicted of a crime, and then the new statute as written would extend for another 3 years. I mean, that's your reading of it too, right? of the second factor?
I think that's one issue that Judge Vano addressed in his opinion. But I think like what.
How realistic is that analysis on the second factor? I mean, this guy's not going to be convicted of a crime 20 years after the fact.
Well, Judge, Justice Biles, it's a multifactorial analysis. And I think when you, and as you've seen in the briefing, and as I'm presenting to you here today, focusing on one particular factor is not the answer anyway. And I didn't mean
do that. I'm just trying to look at three factors, kind of understand the first one. I look at the second one and I have to scratch my head. I mean, you know, when you get these factors, you kind of decide who gets this one, who gets that one, and then you look at the total. I'm just looking at this second factor, and that analysis does not seem realistic to me that the district court did by saying that, well, he could still be convicted 20 years after the fact. It just doesn't seem to be realistic.
And that if you, I understand what the justice is asserting, but Justice, I believe that, and I'm not saying that the legislature waves its magic wand and determines what the outcome is going to be without obviously constitutional overview by this court as to the law it passes. But Justice, I would assert under these particular facts and under the prior rulings of this court that when we're talking about the implication of a statute of limitations, that is purely within the province of the legislature. And this court has determined that statutes of limitation did not invoke any sort of constitutional or due process analysis, and that they made a public policy decision about how these cases are going to go forward. They arguably revived claims that were long gone as a result of this statute, but they also made a public policy determination and made it retroactive all the way back to 1992, and that said any viable claim that is arguably stale. I mean, they were contemplating not having any time limit and having no statute of limitations with respect to these claims, but it made a public policy decision as to how long they were going to allow that to go. And they raised it 10 years from 21 to 31. And that is my assertion is now the law of the land. And the court cannot interpose itself in a situation where the legislature has determined that what the law is with respect to the statute of limitations, when this court has previously stated that issues pertaining to statute of limitations are procedural only and within the province of the legislature.
Is that true? Is this just unfettered? If this had been 2 days before trial, the statute goes into effect, the case is done?
Justice, yes, that would be the law.
The third factor in this balancing test over the vested right is the public interest in the new legislation that's passed, which clearly was extending the statute of limitations for victims of sexual abuse, child sexual abuse. How does applying this statute to the plaintiff's claim, which is about childhood sexual abuse, further that public policy of extending liability?
Well, Justice Biles, the public policy that was pronounced by the passing of the legislature included an extension of the statute of limitations, but it also included abolishing the discovery rule. And that was a public policy decision that was made by the legislature. And that's what we're here asserting, is that that was peculiarly within the province of the legislature. And the public policy is we want to extend the age limit. They made a decision not to extend it indefinitely and completely do away with the statute of limitations. They raised the age limit, but then they also abolished the discovery rule. And part of the public policy decision in that case, in that instance, would arguably be, we don't want stale claims to be litigated 20, 30, 40 years after the fact, based upon the issue of the discovery rule. And so the legislature passed the law, and this court has previously determined that it's in the legislature's province about what public policy is going to be in place with respect to the statutes of limitation.
The legislature could have abolished the discovery rule without extending the period of liability for plaintiffs, though.
They could have, but they didn't. And that's why we're here. And that's the law that they passed, and that's what they're dealing with. And this court has made a determination that the legislature passes law within the province of the statute of limitations, that that's peculiarly within the province of the legislature, and the parties don't have vested rights in the extension or declination of claims under the statute of limitations.
You keep stating that line, but you are also making arguments and acknowledging our three-part test. It's not your position that that should be overruled, correct?
The three-part test, I believe, is part of the analysis, and I believe that this court has used that three-part test, and it's how it's analyzed these particular issues about the statute of limitations and about how that three-part test comes out would be towards following the legislature, because it would be determined that these are not substantive vested rights, but are only procedural within the control of the legislature. And so I would even assert that it's for the court's consideration as to whether that three-part analysis would apply under situations where there's been a determination that the legislature is enacting statutes based upon and announcing what public policy will be with respect to these issues. That do we even go down that road? But if we do, then I believe that three-part test would follow you and would point you to the outcome that we had with respect to the district court's decision.
Mr. Riggs, I think it's Mr. Niswanger's turn. Thank you.
I appreciate it. Yeah. Thank you, Justices. I appreciate the time and attention you've shown to this matter.
And Mr. Niswanger, I show that you the time was divided 9 for Mr. Riggs and 3 minutes for you, so you may proceed.
Thank you, Your Honor. Anytime the statute of limitations gets changed, somebody's ox is getting gored. And this analysis of the three-part test in the context of the statute of limitations has kind of been bewildering when you look through the case law. I think the task before this court in this case is, does the legislature get to set the statute of limitations or not? And they've obviously struggled with what the statute of limitations should be for these childhood sexual abuse cases, and rightfully so. Justice Biles, you commented on public policy wanting to extend more time. But the amendment actually worked both ways. It potentially limited the time because you don't have the discovery rule in effect. And I think that's a recognition that there is an interest on the part of the potential defendants in being able to defend themselves. You commented that somebody's not going to get convicted for a crime 20 years after the fact. Well, the passage of time impacts on everyone, not just the plaintiff, but the defendant and their ability to defend the case. And what the legislature has done here is strike a balance that 13 years is it. We're not going to have discovery where somebody has a repressed memory when they're 45 years old, and now somebody has to go back and try to figure out whether they were on a camping trip back in 1977. We're going to have 13 years, and that's what it is. The language in the statute couldn't be clearer that it's retroactive. And I believe that the cases that Joel cited support that proposition. This isn't a frequent situation that you come up with that we're dealing with today, but to give the legislature its due, they are the lords of the statute of limitation, and our job in the court is to recognize that.
Right, but that's what I was saying earlier. So let's say that the text clearly shows that the legislative intent was for retroactive operation, But our case law is just as clear, you know, in Resolution Trust Corporation versus Ernie Fleischer, that we apply this three-factor test to make sure that the Constitution is not violated in applying these changes retroactively. And I think that, you know, what's going on here is you guys are going over and over and over, you know, yes, the statute does show retroactive operation. But as Justice Biles said, that is not the end of the analysis. You've got to go on and say, you know, was the person deprived of, you know, constitutionally deprived of a property interest? And I think, you know, one of the things that we have to do is, this isn't just about this statute. This is, you know, this was, you know, the Resolution Trust Corporation. This is going to apply to every kind of case. So you could have a situation, if we go your way and say, okay, forget the three-factor test, no matter what, as Chief Justice Rosen said, then we're going to have situations where people are deprived of their constitutional rights.
Justice Standridge, I respect your position. I'm not sure that the three-factor test necessarily has to be applied universally in every legislative setting. What you've got right now is case law saying the legislature sets a statute of limitations. I mean, if the statute of limitations, if the event giving rise to a cause of action somehow triggers a vested right, I mean, there's the magic of having a lawsuit filed somehow vesting a right. I mean, there's no vested right until you get a judgment. You have a claim pending.
What's your authority for that? Because that's not what Resolution Trust Corporation says.
And
It doesn't say that you have a vested right in receiving damages. You know, the claim constitutes the vested right.
And I understand that. But what I'm saying is, if we're going to say you have a vested right in a claim, whether there's a lawsuit filed or not doesn't make any difference. It's
right.
Do you have a claim?
Right.
And if the vested right is the claim, then the statute of limitations once set can never be changed because it's going to impact on one party or the other. And I think that the most solid rule that the court can come up with is the legislature sets the statute of limitations. The vested
But
right.
you would get rid of this three-part test. That's what you're asking us to do. Overrule, you know, decades of case law, because to find your way, that's what we'd have to do.
I don't think that's necessarily true either. I think the third factor in the test, the public policy aspect of this, also favors allowing the legislature to fix a time.
Counsel, I understood your colleague to argue, again, don't abolish the three-part test, but we have case law that says statutes of limitations are procedural in nature. That's the first prong of the test. And
Right.
therefore you're done.
Right.
So it's not, are you disagreeing with that, or
No,
is that your position as well? That you do apply the three-part test, and we have case law that says statutes of limitations are procedural in nature, therefore there's no vested right.
I agree with obviously what the case law is. I think the application in this case is not on all fours with any case that's come down on the statute of limitations. And I think in this case.
Well, why not? I understood you'd argue that it was on fours.
Which case?
Well, I don't have the names in
Okay.
front of me, but the cases that simply state that statutes of limitations are procedural.
Right, and I'm on, that's exactly what I'm saying. I'm saying the three-part analysis, there isn't a case that fits exactly the facts in this case. What we have on the three-part analysis, though, if you're going to apply it, though, is that the public policy consideration that goes along with it isn't necessarily in favor of applying or disregarding the language in the statute and applying this amendment only prospectively.
Well, I don't understand if you're saying that if the text clearly shows legislative intent for retroactive operation, and then you know, our case law says that statutes of limitations are procedural, why would there be a three-part test?
Well,
I don't really get, I mean, there's no need for a three-part test if that's what
Well, I think the three-part test grew out of statutory changes that did not apply, that were not statute of limitations. And then it's washed over into the statute of limitations
What?
area where, I think the law has always been dating back to the late 1800s that statute of limitations are procedural and the legislature gets to make a pronouncement on it, and that is the end. And then the three-part test has grown out of various changes in statutes that are trying to be applied retroactively or prospectively. And I think in this case, one of the tasks before the court is to set forth a really strong rule. What is the law that applies here, and not kind of erase some of the ambiguity that may be out there.
I can't reconcile what you're saying with White case, which was the 1507 Manifesto
Right.
of Justice thing, because I think it was a very clear statement from this court that these kinds of cutoffs mean that statute of limitations are not necessarily just procedural, that there's a blend of procedural and substantive. So I think White is probably closer on point to this case and says the opposite of what you've been saying. So how do you reconcile that case?
Well, I agree with you that we've got kind of this blending of what's procedural and what's substantive. And I don't know that White provides great guidance on this situation, but to the extent that it is, in play, I think what we have here is this conflict where you've got a clear directive versus a claim that has not matured beyond being a potential claim. And that's why we're here, I think.
Any other questions, colleagues?
Just quickly on the statute, the newly amended statute itself, the second or the new provision about X number of years from the date of a criminal conviction. And of course, there's some question, at least arguably, whether that would assume it would apply only in instances where there had been a criminal conviction, or what happens where maybe there's an ongoing investigation yet, no conviction yet. I just want to know, do you believe there's ambiguity in that newly added provision, or is there a plain language interpretation that supports the outcome that you prefer in this case?
Well, I think Judge Vano applied the plain language of the statute. When I sit back and look at it, quite frankly, I'm not going to try to tell you that I would necessarily reach the same conclusion he did. But I think if you apply the plain language, that is the law. And even after 20 years.
Well, there hasn't been 3 years from a criminal conviction in this case. So.
No, there's been no criminal charges ever in this case.
Right. I guess that's my point is, do you agree that there's no ambiguity then?
I do agree.
Well, what would happen, because there's no statute of limitations on rape. So what would happen if 4 or 5 years down the road, they did decide to bring criminal charges?
I think that's a great question. And the way I read the statute is that the statute for at least the perpetrator would begin to run on the date of that conviction. Reading the statute, the thing that I wasn't.
No, I'm talking about the action for recovery of damages. It says, shall be commenced the 13 years or more than 3 years after the date of a criminal conviction. So let's say whatever happens today happens, and then law enforcement decides to, or the prosecutor decides to charge this pastor criminally, and the pastor is convicted.
Right.
Then she gets to sue, right? Within 3 years of that.
Right. I mean, that's ironic being here the day after Easter, but it's sort of a resurrection provision in the statute that if the 13 years has passed and then there is a criminal conviction after that, there's a new triggering event for the 3 years. And that's what the statute says. And I think there's certainly some rationale for why the legislature might have felt that way. And we can get into it if you'd like to, but
Thank you.
It would certainly be unusual for there to be a statute of limitations defense on one day and several days later, that defense doesn't exist and the claim's revived.
I agree with you fundamentally. And in looking at the statute, the rationale I came to for the reason the legislature put that 3-year revival provision in is that presumably if you have a criminal conviction, the standard of proof is greater. And there was evidence, strong evidence to support that conviction, even 20 years or 30 years later. And the legislature made a decision that if there is a case that is that strong, even though it's been 20 years or 30 years or whatever, then you get 3 years to bring a claim. And it kind of, gets away from that issue with the prejudice to a defendant trying to, defend a civil case decades after the fact. That's my only interpretation of what that's intended to do.
Any other questions, colleagues? Thank you, Mr. Nicely.
Thank you all.
May it please the court. Michael Blanton on behalf of the plaintiff and appellant AS. I'll suggest to this court, but first of all, it's obviously our position that the amended statute does not apply retrospectively. It should not be in this case. And I think there are at least 3 paths that the court can take to get there. Briefly, however, I'll address the jurisdictional question the court directed us to. Put simply, it's our position the court doesn't have jurisdiction. I believe the statement in the underlying order would not be a final judgment in any sense because it's simply a statement of alternative action about what might happen under other circumstances. I don't think that's a final judgment. But even if it could, I'm sorry
to interrupt, but just real quick, is it a judgment in any sense?
Well, I don't think it is, but even if you could view it as a denial of summary judgment and somehow, that's still not a final appealable judgment.
I understand that argument. I guess I'm just getting to, if we do send this back, it's an alternative rationale. Is that even a thing or is it just dicta? In other words, do the parties, if it does go back, have to relitigate that? Or if it goes back, I could envision a scenario where the plaintiff would argue, that court's already, it's law of the case. The court's already decided this.
I don't think it would be law of the case.
Okay, thank you.
So,
You're definitely going to litigate that issue if it goes back. I mean, you're either going to litigate it by summary judgment because they'll file it arguing it, or the jury's going to have to decide what the reasonable discovery was, right?
I think that's accurate, Your Honor. And my short version, my experience with summary judgment orders, particularly denial, is that's always the judge's thinking on the matter at the time. They're always free to go back and change their mind, regardless of how they described it previously. So I agree. I don't think it's determinative one way or the other. The first place I'd like to start, and I'll hit this briefly, is that I don't think the court even needs to reach the issue of retrospective application because this action was actually filed 2 years before the amendment. And this court has repeatedly indicated that when you're deciding which statute of limitations applies, it's the statute in effect at the time an action is filed. And there's a good reason for that rule because the statute of limitations by its very nature is focused upon the time of filing. That's the question that the court asked. Was it filed in time? So I think this court can simply find that this action was filed under the prior statute and that the amended statute 2 years later does not control in this case, quite simply because that was not the statute that was in effect at the time this action was filed.
Is it fair to summarize that argument as, I'm thinking on the fly here, but it strikes me that that argument is attractive in the sense that it defines a statute of limitations as exclusively governing the date of filing. Is that the right way to think about this?
It is. So in
other
I
words,
made the point well enough. That was exactly my point, is that a statute of limitations by its very nature is focused upon the time of filing.
So once a case is filed, it doesn't even really matter what happens after that because the case is alive and it either complied or it didn't comply.
I think
The
that is,
limitation on filing.
I think that is accurate, Your Honor. It asks a one-time question, and once it's filed, that question has been asked or at least been presented and determined.
Is there any case law that articulates it the way I just articulated it, and you did as well?
I've not seen any case that provides further detail on that, certainly not under the facts of this case, but I think that is a rule that this court can apply in this case. And in that instance, the court doesn't even need to reach retrospective application. But assuming this court might reach that question, defendants have argued repeatedly that this is a procedural statute and procedural statutes apply retrospectively. But this court has repeatedly recognized that even when you're talking about a procedural statute, it still may not be applied retrospectively when doing so would impact a vested right. And as Justice Biles noted, in the White case, this court specifically stated, quote, while a statute of limitations is a procedural rule, which means changes typically apply retroactively, a change to the statute of limitations does not have retroactive effect if it eradicates a vested right. I don't see how it could be any clearer than that. Now, obviously, the Owen Lumber factors for vested rights apply in this case, but before getting to those three factors, I think it's useful to consider the series of cases which address a vested right in an accrued and pending tort action. In Resolution Trust Corp versus Fletcher, this court addressed the question of whether the holder of accrued tort actions, which have not yet been reduced to judgment, have a vested property right in those actions. And this court held that parties do have a vested right in such actions. And that's exactly what this is. These were negligence actions. Yes,
Does that rationale really make sense? And what I want to drill down into is, what's the difference between the right at issue on the day before the case is filed versus the day after the case is filed?
I think filing does make an important difference.
And why? Why? Just conceptually, I understand practically, but
when you have an accrued right, you have a right that you may or may not exercise. You have an option, you might say, to exercise that right, and it's open for a certain amount of time. When you file, you've exercised the right.
But why does that change the analysis of vesting? In other words, why is the right not vested the day before you file? That's what I'm struggling with, that idea, which is in Resolution Trust.
Right. And I would note, not only in Resolution Trust Corporation, but in Holt v. Med Center, this court reaffirmed that holding 9 years later. And 7 years after that, this court again reaffirmed that holding in Brannon v. Kansas City Guarantee Association. But going back to the question, I think it is important that you not only have a right, in theory, an option, but you've invoked that right and you're acting under that right once you file the action.
And I understand that.
I think that's important.
I just, is there case law that in any sort of the law of vesting that describes the taking of an action as, I mean, you're sort of self-vesting the right then? I'm struggling with why isn't the right vested the day before the lawsuit's filed?
Well, and let me say, and maybe I've taken the question the wrong way. I believe the right's vested even when it's just accrued, but I believe it's even a stronger argument that it's vested once.
But you're at least, your position then would undermine the rationale of Resolution Trust.
Correct. And obviously Resolution Trust does speak, although it addresses a matter which was accrued and pending, already filed, it repeatedly spoke in terms of accrual. And in that case, the court stated the right to a cause of action has long been held to be a protected property interest. And that we have recognized the accrual of an action as a significant event, and it even linked the moment of accrual to the creation of vested rights. So I absolutely agree. And I don't mean to limit myself solely to the situation where it's filed, but I do feel that your case is, for lack of better terms, even stronger when you've actually filed your accrued action. Now, turning to the Owen Lumber factors, the first factor is the nature of the rights at stake. It seems to me defense counsel has suggested statutes of limitation or procedural. That's it, we're done. I respectfully disagree. I don't think we're done. But I don't think that even directly addresses the factor, because the factor is the nature of the rights at stake. It doesn't ask about the nature of the statute at stake. And sometimes that can overlap. But in this instance, I would suggest the right at stake is the right to pursue an accrued and pending tort action. And this court has repeatedly held, as we just noted in Flesher and Holt and Brennan, that a pending tort action, which is actually accrued and been filed, is a vested right. It should be treated as a substantive right. So I think for purposes of the Owen Lumber factors, we should really view it as a vested right or as a substantive right. That's also consistent with what this court stated in White. Quote, while we generally consider a statute limiting the time in which one can bring a claim to be procedural, we have recognized substantive, at least vested aspects when limitations periods change. So this court has previously held that even though a statute of limitations is procedural, it can sometimes involve a substantive right. And I think the right at issue here is substantive.
When your rationale, especially if we go with the accrual of the right being
Yes.
the key moment of vesting, would that apply equally to defendants in your view?
I'm not sure I understand the question. Your
Well,
Honor.
for example, if we had the timeline flipped around, and it was the argument for a plaintiff was making is that the time got extended, and the defendants here saying, no, we had a vested right in the shorter time period, would the argument equally apply?
Is this under a different statute?
The
are
argument
we
would
saying?
be, the defendant would be saying, I got away with it.
Okay, okay.
Well,
Now you
I
can't tag me.
I'm sorry.
yes, I'm sorry for the crosstalk. I don't mean it as a gotcha. I mean it as a legitimate question about the implications of the argument. I'm just trying to understand
Right.
if defendants, in your view, also have a vested right in an existing statute of limitations.
I think that could be the case, Your Honor. I think the same factor analysis applies. All parties have some right in the law as it existed as they were proceeding, Your Honor. As to the second factor under Owen Lumber, how the rights were affected, I think it's clear here that the plaintiff's right to proceed would be completely eliminated. As Justice Biles noted, Judge Vano suggested that that wasn't true because it's possible someday a criminal action would be brought and then she'll have a revived action. I don't think that's realistic, and I think we should look at the facts as they actually exist at the time we're applying the factors, not under some hypothetical scenario that might happen someday. As to the third factor, the nature and strength of the public interest is furthered by the legislation. I think allowing AS's claim to proceed in this case would be consistent with the public interest of allowing redress for childhood sexual abuse. But this court need not accept my suggestion about what the purpose of the statute is, because as this court has recognized, the legislature's intent or purpose may be discerned by looking at the preamble of the statute. And the preamble to the statute in this case specifically states the purpose of the statute is to extend the time to file civil actions for recovery of damages caused by childhood sexual abuse. Allowing AS's claim to proceed and finding that it's not somehow retrospectively barred is entirely consistent with that purpose. So the factors.
It seems to me that defendants have a decent point, though, to say, yeah, I mean, the statute does extend some victims' abilities to go file litigation. But looking at the plain language of what the legislature did, it struck the discovery rule. And that's the only thing that's keeping you alive in this case is the discovery rule. It seems to me on the public policy side that this is a mixed bag. I mean, I'm drawn to the extended rights and all that, but in this case, the legislature specifically said we're going to do away with the time, an analysis of when the defendant or the plaintiff, discovered the causal impact of the.
In the most direct sense, that's true, but I'm not sure that's true in practice, Your Honor. As Justice Wallaby was asking about how the statute works in terms of the criminal conviction part, the statute says that the statute runs at the later of two events, 13 years or 3 years after a criminal conviction, I would suggest that if there's not a criminal conviction, then the statute has not yet run. And I know defendants will argue, well, that means if criminal charges are brought. But respectfully, the statute doesn't say that. The statute doesn't say 3 years after a criminal conviction if criminal charges are brought. It simply says 3 years after a criminal conviction. So in this case, the statute, even under the new statute, and we've argued this in our briefs, I don't believe would have run. And it actually fits with the discovery rule, because if you think about it, you have 13 years to bring your action. If a criminal action has been brought and there's been a criminal conviction, then, you would still have the 13 years or 3 years later. And why would a criminal conviction be important? Because if there had been a criminal action in which somebody was convicted, you would have discovered what had happened. So it addresses the same issue that the discovery rule would have addressed. I'd like to briefly address, would it be possible to have a few more minutes,
Yes,
Your Honor?
yes.
Thank you very much. I just wanted to briefly touch upon the cases from this court, which indicate that even when a statute of limitations is amended, a party must still be allowed a reasonable time to pursue their action, that a change in a statute of limitations cannot act as an immediate bar. And I think those cases, one, they're they're on point here, but two, those cases also speak in terms of those constitutional limitations, that the legislature can say what it wants, but the legislature can't by fiat dictate that something unconstitutional happened. And in those cases, this court has repeatedly indicated that even if the legislature intends for a statute, an amended statute of limitations to become effective immediately, it still doesn't work that way. A party should still have at least a reasonable time to bring their action. And that's when you're dealing with actions that are only accrued, not even filed. If it'll protect an action that's not been filed, but is accrued, surely it protects an action that has been accrued. And I would also,
some of that authority is pretty dated too. I mean, in a sense, you could say well established, but what are the doctrinal underpinnings for that rule? Or is it a procedural due process? Is it a vested rights, a substantive due process? Do you?
and I apologize, it's certainly a constitutional analysis. I don't at this point recall the express language or the express analysis from Milbourne. I will say that that authority is not as old as it might seem. Defendants like to say a 110-year-old case. Well, the first one in the series is. The last one was in 1981. So it's not as old as they make it seem. But I think it's the basic idea. And going back to what the White Court said, that, the legislature can pass a statute of limitations, but even if it intends to make it apply retroactively, there are still constitutional limits. This court has repeatedly recognized that fact. Defendants have also mentioned the notion that, a party has no right to no vested interest in a particular remedy or procedure. And that is a principle that you see in the case law. But I would note in both Resolution Trust Corp and in the Brennan case, this court specifically addressed that rule and said that rule does not apply when an action has already been filed. And that might be another reason that is an important marker, whether the action has been filed or not. Unless the court has other questions, I'll just conclude briefly.
Yes, go ahead.
So as I mentioned, I believe the court has 3 paths to conclude that the amended statute does not apply retrospectively against AS in this case, and all of those paths lead to that conclusion. In the end, I think this is a question of fundamental fairness. And I can tell you, I've been arguing appeals for 30 years. I don't often invoke fundamental fairness because it's an overused phrase that you hear all the time. But I think this is the quintessential case where this is a matter that involves considerations of fundamental fairness. It's fundamentally unfair to tell a party who filed their action, complied with the statute that applied to them, and is 2 years into their action, that suddenly their action has gone away because of a subsequent amendment of the statute of limitations. I thank you for your time today.
If you have a question. Thank you. Mr. Riggs, you reserve 3 minutes.
Thank you again, Justices, allowing us to present these arguments, and Mr. Blanton did a good job of presenting the counter. With respect to the three-prong test, we've heard a lot of reference to the RTC case. The three-factor test was applied, and it was determined that the change in the law should not affect the plaintiff's claims in that case, but the plaintiff's claims were the type of claim being asserted rather than the procedural aspect of the case. So factor one, as Justice Stiegel, sorry, pointed out, is that when you are dealing with procedural rather than substantive rights, that is a key issue that needs to be addressed under the three-factor test, and the RTC versus Fleischer case is not, and the Holt case are not on point with respect to those issues because they don't deal directly with the statute of limitations. They deal with the actual claims that were being asserted.
But the White case deals directly with statute of limitations.
And the White case deals with, I think that was a 1507 case. And I don't think it can be directly applied to civil claims and civil actions as of the normal type rather than 1507 type claims. And those are different rights and obligations and duties that are invoked rather than just specifically whether a person has timely and procedurally applied with asserting a civil claim for damages.
Well, both are civil remedies, right?
They are both
One
governed under
a statutory remedy.
Under Chapter 60. That is true. But I believe when we're looking at the three-prong test or the three-factor test, and we have the cases that determine that nobody has a right, a vested right in a statute of limitations, be it what the ability to prosecute or the ability to defend the claim, is a different situation, obviously, than a 60-1507 file. And then when we're going down this road, and I want to just go back to the public policy argument to conclude my argument, which is public policy with respect to the enactment and of the statute of limitations rests peculiarly within the legislature. And Justice Biles noted, well, it's within the prerogative of the legislature to determine whether the discovery rule should or shouldn't apply. With respect to the retrospective or retroactive application of this statute, if the court were to determine, and that's part of the reason we pointed out that this court needed to assess this, under the Court of Appeals decision, they're stating that the clear statutory language that says we're going to apply this retroactively doesn't apply, and it completely rewrites the statute and basically judicially interlineates the statute by scratching that out. It is also then not allowing the revival of claims under the age limit rule, which appears when the legislature said, hey, how do we do this? And how do we make sure that it applies retroactively? And then they enact the statute and make a policy decision about how long they're going to extend it. This cuts both ways, as the justices were kind of pointing out. It's like, well, does the defendant have a vested right? Does the plaintiff have a vested right? They don't have vested rights, and they're purely procedural, and it is purely within the province of the legislature to make these public policy decisions, and the law should be enforced as the legislature wrote it.
I have a very quick question. I know you're out of time. At least I hope it'll be a quick question. I just wanted to give you an opportunity to respond to plaintiff's counsel's argument that most of the things we've been talking about are a big distraction. I'm putting words in his mouth. Basically that we don't have to look at vested rights. We don't even have to look at retroactivity, because statutes of limitations by their very nature are very narrowly focused on one thing, which is the date of the filing. And so this is a very simple, clear rule. Date of the filing, you ask the question, yes or no. That's it. And I just wanted to give you a chance to respond to that.
Well, if we're going back to the Milborn case and those issues, I don't believe, like I think we pointed out in the briefing, that the courts have gone inexorably from mixing and matching statute of repose issues and statute of limitations issues until they diverged in the late 80s and early 90s, like with respect to the I can't remember the name of the Harding case that we're talking about now. I don't think it's the date of the filing determines how you apply the statute of limitations and whether you're in and out of time, but it is for the courts to enforce the statute of limitation as adopted by the legislature. And so I don't think that there is a specific, just because the action is filed does not mean that the law that applies to it as enacted by the legislature should be forever barred from doing that. Otherwise, why do we have these cases that say we can retroactively apply statute of limitation to revive claims? And so just to conclude, Justice Stegall, thank you for that opportunity to address that particular issue. The legislature passed a law. It is peculiarly within the province of the legislature to determine public policy with respect to these issues. It's plainly written and it was enforced appropriately by the district court judge, and the appellate court decision judicially interlineates that statute, and it's not permitted under the law of this court. Appreciate your time and attention.
Thank you, Mr. Riggs, and counsel. Thank you all for your arguments this morning. This court will take this particular appeal under advisement